All right, we'll try to make a quick transition here. I think we're waiting on a mic for one of our speakers, but I'll go ahead and start doing just some introductions. So we are talking about a topic near and dear to our heart. Those of you who are fortunate enough or unfortunate enough to have sat with us at dinner last night or lunch today might already kind of be bored with this particular topic. So we hopefully we'll kind of try to stay on task somewhat. What we are trying to do today is not kind of kill you with acronyms, and we're also trying to play Switzerland. Some of our speakers today represent particular segments of the market, so we'll try to kind of avoid that, so to speak, and be Switzerland. But we are going to try to talk about what it really means to have fiduciary risk transfer, and part of what kind of even prompted this whole thing is I feel like there's been kind of a bit of a shell game and some shenanigans, and it's become kind of a marketing ploy, so to speak, with retirement and pension. And so we really kind of want to drill down to it. Our speakers, I'll start with Bret Hamlin. He's actually seated in the middle, but Bret Hamlin, he and I recently did this exact panel down in Tampa for the Retirement Advisor Council. He is a shareholder with Hill Ward Henderson Law Firm, a graduate of the University of Akron. He serves the employee benefits industry in a variety of ways, both local and national. So from the Tampa Bay Pension Council all the way up to the Employee Benefits Committee of the American Bar Association. Ted Schmelzle is all the way down there at the end. Ted is also an attorney. He says he's a recovering attorney. He did graduate, though, with honors from law school, and William Mitchell College of Law was where he went to school. Honestly, one of the smartest and nicest guys I know in our business, and I'm fortunate to have him here today. Graduate of St. John's University, so he's a Johnny. He started working at Securian Financial 26 years ago, and literally just worked his way up from, I don't know, the mailroom, I don't know, but from senior counsel to general counsel to basically he runs the retirement plan record keeping shop for Securian. Securian, by the way, is one of the organizations that provides some fiduciary risk transfer opportunities. Troy Tisue, he's right here closest to me. Troy is the person that you may have even heard this term before, open MEP. He's actually the man who coined the term open MEP. I think you have that registered. He founded TAG Resources 21 years ago. He's a pioneer in the multiple employer industry, and many of the things that you see today, from the 316 model to pooled solutions and things like that, are really things that kind of grew out of what TAG Resources was doing quite a while ago. He's a graduate of the Citadel. He lives with his wife and 3 daughters there in Knoxville, which unfortunately means he has to pull for the big orange, but we're gonna try not to help with that dumpster fire. Oh, and by the way, our condolences for the Tennessee thing, but our congratulations are in order because TAG was recently acquired, so they sold the company to Transamerica. And so he is now with TAG Resources. It's a company of Transamerica. I will say there are some resources out there. I know Transamerica is one of our sponsors, and then Securian Financial is one of our sponsors. And so there are some resources, some white papers, some additional information about 316 services and what does it really mean to be a 316, things like that. So you might want to grab those kind of things out there that are on their booths. So without further ado, sorry, I meant to be on that slide when we were making these introductions. I'm the moderator. I'm Troy. So why does this matter to actually be involved in fiduciary risk transfer? So we'll start with you down here, Ted. Why does it actually matter? What's really the regulatory risk? What's really at stake? Why is this a big deal?
Yeah, so first of all, thank you for having me, and thank you to my colleagues here. It's wonderful to share the stage with people of your caliber, so thank you. This is really the punchline when you look at the statistics here. If you go to DOL.gov and then go to EBSA and then go to About Us and then go to Enforcement, you'll see pull up PDF and it'll show you what they collected in 2021. They have it every year. It's a badge of honor. And in 2021, I believe it was $2.4 billion. So there's a lot of money at stake here from a regulatory perspective, primarily on that side of the fence, on the administrative stuff that goes on within a retirement plan. And a lot of that is through VCP and other lost and missing participants, things like that. But it is definitely the case that the Department of Labor on the administrative side, if you've got a plan and that plan happens to get audited, or if they've got one complaint or two complaints, and then somebody starts to take a look at the plan, that there is significant risk from an administrative standpoint, potential fines from the Department of Labor. So that's really a good reason as to why. On the investment side of the fence, Tale of Two Cities here, that side is primarily driven by civil litigation, of which you all know, right? We've had that for the last 12 years, where plans are sued routinely for fees and expenses that are charged. And on that side of the fence, as opposed to the administrative, commonly called 316 type duties. So that's, the minutia of retirement plan, money in, money out, loan administration, all that. That's more regulatory. And then on the investment side, you've got folks that can help kind of offset risk or transfer risk to. That would be a 321 or a 338 fiduciary. That side of the fence is primarily driven by civil litigation, and so it's a little bit different, but definitely still a fair amount of risk.
One of the points on that slide there says something about kind of how it's generally employer oversight. So Bret, that kind of makes it sound like it's just an honest mistake. I assume the regulators always kind of take that into consideration, and just an honest mistake, right?
Well, a lot of what the Department of Labor finds when they do investigations of plans are what they're looking for. They've got certain hot button topics that they're looking for. And when we're talking money right now that the employer might be subject to putting into the plan, it's because in most cases, employee deferrals that are withheld from their paychecks aren't being deposited on time, or in some cases, not deposited at all. And the Department of Labor steps in either because they see something odd on the 5,500 or because there's an employee complaint. And so they really don't have a whole lot of leeway to be nice, to say, oh, that's an honest mistake. Go ahead and make it right going forward. And we're going to let you off the hook. You don't have to put that money in, or you don't have to put the interest in that the participants have missed out on because their money was not invested in a timely manner. So from that perspective, I understand the regulatory environment and what we've got going on. And especially if you're a plan sponsor that's been subject to one of these investigations, they can go on for a couple of years. And it's a real pain, not only the money that you might have to put into the plan, but just your human resources that you're having to invest in that particular investigation. However, I think the much bigger risk to plan sponsors is the litigation we've seen, and I think we're going to continue to see it. Most of that litigation in recent years has been related to the fees associated with the underlying investments that participants are paying, and the litigators are out there, the class action attorneys, are saying, well, you could have got this fund, the same fund at a cheaper cost. And so I think that's where the main exposure is when we're talking about money associated with employers having to put it into the plan because they didn't do something right. And as this litigation continues, we've seen the big firms in the country go after these companies. And in many cases, there's no court judgment. It's a settlement. What happens is the company weighs the cost of litigation and they say, boy, can we just make this go away? So we're going to settle. And Boeing, for example, I probably have the number wrong, but they were one of the first ones. And they said they had a settlement where they had to put $70 million into their plan. It was a huge plan. So 70 million was a drop in the bucket. But I truly think that that's where we're going to see this going forward, because as smaller areas, smaller plans are impacted, because other attorneys who haven't done this type of litigation are seeing what the Schlichters of the world have done and basically doing copycat cases.
Right. Yeah, the roadmap's already there. We put together some slides. We thought it might be helpful to kind of know who's on first and kind of who the roles are and such. So when an employer, a plan sponsor, is sponsoring a retirement plan, the very first step in that process is trying to figure out who's going to be responsible. I mean, before you set up the plan document, figure out the plan design or whatever, you got to figure out who the plan fiduciaries are. I believe a plan fiduciary needs a plan fiduciary advisor. There is some fiduciary risk outsourcing with a plan fiduciary advisor, not a ton, but there is some. And they certainly don't take on the roles of the record keeping process or the administration process. Oddly enough, those are things that are primarily ministerial in nature. They're just doing things that are non-fiduciary, unless, of course, they've outsourced to an ERISA 316 administrative fiduciary. There's also some outsourcing that can be done under ERISA 321 in a kind of a co-fiduciary sense to the plan fiduciary advisor or an ERISA 338 investment manager. And so what we're really talking about is kind of filling all the seats at the table. And we're really asking, is it worth it? Is it something that fiduciaries should do? And so maybe we'll just start with that question. As you understand exactly the way the regulations are written, Bret, what should a fiduciary do?
So this particular slide kind of summarizes the requirements under ERISA, under the statute, that say, here's what you need to be, how you need to be discharging your duties as a responsible fiduciary. And while all of these are very, very important, for purposes of our conversation today, I think that the third bullet item is probably the most important one. And this deals with the duty of prudence. And when you actually read the full explanation of this, it leads you to the conclusion that it's not just a prudent man rule, but it's a prudent expert standard. And so most plan sponsors aren't prudent experts. And what they need to do in order to satisfy and discharge their responsibility is they need to retain the advisors who can provide the advice to them so they can make those decisions in a prudent manner based upon the advice they've been getting. So I don't want to go through all the detail, and in essence of time, that was the one that I thought was most important to our discussion today.
Okay. And incidentally, that's the kind of the genesis around why the good heart, empty head defense doesn't work. As we were talking about before, you can be completely altruistic and have a clean hands, but if your head is empty, it just doesn't work.
Yeah.
Kind of sounds mean, empty head. That's law school stuff.
So there are a variety of ways in which you can do what we call fiduciary outsourcing. And this is kind of a really quick overview because we're going to dive into further definitions of these. But Troy, how would you explain some of these? What is the mitigation of risk under these provisions?
Yeah, so we're playing with acronyms now, and I don't know how much caffeine you all have in your system still, right? But I'll say this, like the most important thing, when we talk about fiduciary outsourcing is not necessarily these specific, acronyms or terms. It's the three words that really matter the most. When you're dealing with a retirement plan as an employer, the reason you look to outsource a lot of the risk is because of other people's money. That's the core problem, right? And that's where all the risk comes, right? Because you have to do it right. And just like Bret said, you're held to a standard that's very, very high. And if this isn't what you do for a living, which most of us don't, you don't want to play in that arena, right? Because it's not your money and you're making decisions on it. So again, that's the real risk. So these specific roles that you see here, from a 321 to a 338 to a 316, they just have to do with the specific ways you can allocate those responsibilities to another party. So you can really carve out that specific risk, associated with controlling someone else's money. The 321, Troy mentioned this earlier, it's a model where you're kind of sharing that decision tree with an advisor or another party, where you're both kind of coming to a consensus on what you want to do. You're not skirting all the liability entirely, but you are making that decision together. When you get into the other two, 338 or a 316, these are very, very specific. One's more operational in nature, the day-to-day aspects, that's a 316. And consequently, that's where most of the action happens. It's kind of that death by 1,000 cuts. If you don't do this part right, it might not be the huge ticket that you see on the investment related lawsuits that have been in headlines, but it's a lot of blood at the end of the day. Like there's a lot of little fees you're paying along the way. And the 338 is the one that we hear the most of. That's directly related to the investments and the decisions around those. So those are the roles that you can specifically, carve out this risk and give that to another party to take on for you.
Okay. We'll jump into the role of a 321 specifically. Bret, how would you describe a 321 and how important is it to have a 321?
Well, I think Troy did an excellent job of explaining it, but just to kind of distinguish, and I know Ted's going to talk about the 338, but you might say, well, what's the difference if some advisor is coming to me and saying, we can provide 321 services to you or your committee, or we can provide 338 services. 338 and 321 have been around for a long, long time. However, in the defined contribution arena, we didn't see a whole lot of 338 services being offered for years. It was mostly the old-fashioned defined benefit plans. And so as Troy indicated, a 321 is somebody who is providing advice to the underlying fiduciary. So if you're set up, so you have a committee at the employer that's responsible for the plan or plans, and they go out and hire somebody to provide advice, and that somebody is a 321 investment advisor, then who's actually making the decision? Not the advisor, they're providing advice. The committee's making the decision. So that's the distinction as compared to what Ted's going to talk about in a moment on 338. And your other question is, how important is this that plans have it? Well, I know that you quote me from time to time on saying, well, you know, most plans will be well served to have a 321 investment advisor.
Well, you said that, so I
And
like that. I
do.
love that quote.
And you know how I said it because you came back and said, well, wouldn't all plans be well served? And my response to you was, well, as a lawyer, I prefer to avoid saying all and none or never and always. But yeah, I can find examples of a plan that doesn't need an outside investment advisor or an investment manager. Think of a company that does nothing but advise retirement plan sponsors as a 321 or a 338. Do they need to go hire a separate 321 or 338? Probably not. But I stand by my statement that most plans would be well advised to have a 321 instead of merely relying on your record keeper who's coming in and saying, here's how the funds did, and you might want to consider this. You need somebody independent.
Okay, and then there's a big difference between that and 338.
And
Ted.
that's good.
Yeah, Ted, you were telling me recently, you know, y'all serve as a PPP, a pool plan provider, and in that capacity, you've had the opportunity to hire 338. So tell us a little bit about the crazy world of 338s and what you've observed.
Yeah, so really important point that Bret made is that usually fiduciary responsibility follows discretion. And so it's really important to figure out where that discretion lies. And with the 321, correctly so, even though you might be getting advice, the discretion actually is with the committee. So that's where the fiduciary responsibility is at. On the 338 side of the fence, that discretion is ceded to the investment advisor. And that means that the investment advisor calls the balls and strikes for the variable investment options that are included in the lineup for the plan. And you, as the plan sponsor, are responsible for monitoring the investment advisor, guided by the investment policy statement, and making sure that they're doing a good job, but you're not responsible for calling balls and strikes between Fund A and Fund B. That is the province of the 338. That's where the discretion comes in. Again, your discretion is choosing the 338, so you've got fiduciary responsibility for that decision. If they're doing a poor job and you don't fire them, you may have liability. But the discretion relative to the variable investment options populating the lineup of the plan, province of the 338. So that's the difference. And what you said is very true, Troy. We'll talk about PEPs in a little bit, but the Reader's Digest version of that is in a PEP. One way to structure those is where you have an entity called a pooled plan provider that hires the 338. And so while I've been in this business now for 26 years and kind of understand the relationship, the geography, was somewhat shocked when we started to look at 338 agreements when we were actually doing the hiring, because there is quite a bit of divergence between those contracts. And I draw the analogy to what we'll talk about in a little bit as well with 316. The devil is in the details in those contracts. And so some of them cap liability at one time the amount of the fees paid. Some of them have limiting language that have to gross negligence or willful misconduct to a high bar before there's going to actually be a payout, things like that. So it is really worthwhile to engage competent counsel, or have people come to you as that counsel to take a look at those contracts in detail and kind of ferret out some of those differences. One thing I'll say though, in our industry, and certainly I think this is true for Troy as well, but we play in the smaller side of this, right? So Troy, Tisue, and I, and in that space, it's almost, in my estimation, indispensable to have a trusted advisor to help out understanding the market. We're 100% advisor assisted. It makes me a little nervous when we don't have an advisor in the mix, because I know that person can really bring solid and well-needed perspective to somebody that probably doesn't have the resources to do it themselves. So it is really important to have a trusted advisor that can help the plan with some of these things. And it's a need in our market, I'll say, because there's just ample and many traps for the unwary and qualified. It is a target-rich environment with lots of stuff that can go wrong. So that's what
But not all 338s are the same.
they are not.
Yeah.
No. Devil's in the details, I guess. And take a look at the contract.
Devil's in the details.
Yeah, that is so important to emphasize, just because you're looking at two candidates and they may be equally qualified, you got to read the service agreement, because if one of them says, hey, we limit our liability to $5, and I'm exaggerating, and another one says our liability is limited to $1 million, then you got to take that into account. John?
Yeah, it is a good idea to have somebody like Bret those contracts, but it's compulsory language. They could insist upon being indemnified by the employer, but the thing you described is that it is not.
And it happens all the time.
Yeah.
It does, but it's absolutely clearly.
But nonetheless, most of the people that enter into those agreements without counsel, they're not going to go back to counsel later on
I
often.
think it goes back to Ben's point about the need for.
Yep, agreed. And the other point I want to make is, just because you have a 321 and they're advising you and the committee's then making the decision, pulling the trigger, as I say, that doesn't mean that the advisor's off the hook. They've got co-fiduciary liability. So the same thing applies when we're looking at the contracts. We got to look at what that liability is with respect to the advice they're providing that we're relying on.
And I think our audience is maybe somewhat familiar with the idea of 321, 338, 316, perhaps. I don't know if that we're quite as familiar with this idea. What in the world does it mean to be an ERISA 402A named fiduciary?
Okay, you significantly truncated my slide, but basically there's a section in ERISA that says every plan has to have a named fiduciary. So you can be a fiduciary because of what you do, because you're making a decision about the plan, but that doesn't make you a named fiduciary. A named fiduciary is somebody that's named in the document, or the document provides another mechanism to name them outside, and you've then operated under that mechanism to name somebody. So if you look at the plan document, one of the most common ones that doesn't have to be there, but you'll see it almost in every plan, is who's the plan administrator, the 316 as we've been talking about. And the plan document will almost always say that. If it doesn't say it, then ERISA defaults and says, the plan sponsor, if you didn't put it in the document, then the plan sponsor is the named fiduciary. So we talk about this in the context often of when you're hiring a 316 service provider, a plan administrator, so to speak, and I emphasize so to speak, again, you have to look at the contracts, because what I find oftentimes is those contracts will say, here are the services we're providing, and you'll say, okay, I like those 15 services, but what services are you currently providing when we don't have that particular 316 arrangement with you? Oh, well, we have these 11. So oftentimes they're only adding 4 new ones, and you have to look at that and say, well, what's the benefit of having that? But in this context, the question often comes down to, if you are entering into one of those 316 arrangements, would it be best in some cases to also name that entity as the true plan administrator, a named fiduciary under the document?
Troy, what do you think?
This was probably the best $3 I've ever spent in my life. At one time I was giving a speech on this very topic and had my daughter sit down with a highlighter and go through a plan document, which you can imagine. But she did. There were 388 references to a named fiduciary, right, in the plan document. And whether it be a plan administrator or a trustee, and what that represents is there's a lot of pitfalls, to Bret's point. If you don't really dig into a service agreement, you don't know what you're missing, because if you're not named in the plan document as that fiduciary, if you're a plan administrator, what are you leaving out? That's fundamentally, where you start. You got to see is it a service agreement they're offering up? And then you got to kind of go look back at the plan document and see what you're missing. So again, that's, to Bret's point, that's a starting point. If you're not in the plan document, it's kind of like that commercial where you see the kid giving a lollipop and then they take it away. It's not right, right?
Well, you serve as a named fiduciary.
We do.
Correct?
We do.
Okay, so you serve in a 316 capacity with a 402A named fiduciary.
We do.
So does the 316 actually have any teeth without being named as the fiduciary?
Well, let me play the other side of it too. So yeah, I think that it depends on the way you market your services, right? Some people are looking for a scaled back model. Some people have more wherewithal in the institution that they work. So again, there's a place for all these things, and the bookends that compose a 316 are pretty wide open. It's just a matter of what you know that you're buying. Yeah, right. That's the fundamental thing. I think that market materials tend to overstate, the importance of what that role can be. So I think if you do your diligence and you make sure that people around you do the same, you can enter a structure that's going to be great for you, because you don't necessarily have to have all those things. But certainly if you think you're buying them, you need to make sure you are, right?
Yeah. And then we get to the one that maybe we've begun to hear more about, which is 316. And to Bret's point, the 321, 338 has been around for a while. Well, 316's been around for a while. And now all of a sudden, Ted, people are starting to market this. It's like now we offer 316 services. And it is interesting, to Bret's point, that you had these 11 services you were already doing, and you add this one more. And I mean, what in the world does it really mean to be a 316, Ted? What is that?
To me, it's a level of protection. And
Okay.
so really it's about who's going to pony up if something goes wrong. And that might be it might be that the record keeper, the service provider, is doing the whole breadth of the services, but without the 316 protection, if there's an issue with one of them, then, whatever it is, then that would be the responsibility of the plan sponsor as the named fiduciary. So I think that's a really big piece of it as well. I would also kind of emphasize that there's a difference in 316 providers versus kind of monitoring and pointing out, bringing to the attention of the plan sponsor that there's a problem. And those are generally kind of tack-on ones where, again, they'll be taking a look at it, walking alongside the plan sponsor, and then saying they're a 316 named fiduciary, but then the responsibility is such that they're monitoring and then bringing to the attention of the plan sponsor something's wrong. I do think there's a material difference. And this would, I think, be common between Troy Tisue and I and our shops, where we're actually doing the work. So it's kind of like the factory warranty is the way I like to think of it with the car. It's our product. We're doing all the work. We're doing all of the administrative detail and all the work. If we have 316, which comes at an additional cost, then for some of those that we ordinarily wouldn't cover from a fiduciary standpoint, we would cover if there was something that went wrong. And I'll be honest with you, you have to get, in order to say, hey, we're going to do this and take on this additional level of risk, you have to be comfortable that you're doing it well, right? That you're not going to have a lot of situations that you've got the systems in place that you're going to fulfill your duty and not incur any significant monetary liability. But in many instances, it's peace of mind for the plan sponsor. It's somewhat akin to insurance.
I guess the question is, so much of what a service provider does administratively is kind of ministerial in nature. So what makes it fiduciary? What does it really mean to be a fiduciary? Well,
I mean, again, you've got discretion. So, there are many areas where there might be discretion that's exercised. It might be for instance, a distribution of some hardship distribution or approval of a loan, things like that, where there's actual discretion, eligibility determinations, things like that are definitely on the list as well. One thing I will say in terms of what most 316 providers will not cover, and I don't know in detail about Troy on this, but I can say at Securian, we don't cover the provision of data that comes from the plan sponsor, just be honest with you. So if it's bad data and it's coming in, we're not going to cover that. That's a big piece of why stuff goes wrong in many instances, but we do expect data to be in good order when it comes to us. And that's primarily because we have no control over that data and how we get it. If it's bad social security numbers or it could be a date of birth that's actually after the date of hire or something like that. All of those are very common when we ingest data.
And maybe you just answered the question for the skeptics. I mean, what does having a 316 do to help with any of these errors that we're looking at right now? Is it bad data in, bad data out? I mean,
so what Ted just touched on is probably the number one problem in the entire record keeping industry, right? The bad data that comes in, triples the workload at the end of the year, because you're not only trying to reconcile the accounts, but you're reconciling with data that wasn't even correct. And so you have to go back and kind of recreate a story from a year back, right? And it's a horrible experience for all involved because you're constantly going back and forth. You're like, why do I do this? This isn't my job, da, 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 da. And you get clients that are unhappy, you get advisors aren't happy, all parties related to this don't enjoy it. So I would say that the question you asked earlier about what makes a 316, and if you're really looking at adding that to the mix for your plans, or you're really trying to figure out how to discern the better ones from the ones that aren't so good yet, I'd say the two things that really matter, they've got to be in the plan document and they've got to have experience, right? But the other part is, Ted's point, you got to have some kind of mechanism to police the data on the front end so that you have, at least to a very high degree of accuracy, know the data that's going to hit the record keeping platform is solid, because you're going to make decisions on that data, right? Because one of the burdens you're lifting off of an employer is you don't have to get wrapped around the axle with like hardships or loans or all the things that relate, because, you know, money and concerns about money are what people do on their computer all day when they work for you. We all know that, right? It's one of the biggest stresses in their lives. So if you can help remove that, it takes that kind of concern out of the workplace. And so that's one of the things that I think at 316, you know, it does a lot of work, you know, on the side to do. But again, it's all predicated on that data being there, right? So again, there's so much work on the front end you have to do, and that's a big part of it.
So we talked about earlier that all 338s are not the same. All 316s are not the same either.
Absolutely. I was going to make a few points, but John, did you have a question first?
I'm sorry, but I think it's helpful to really think about it like discretion. Giving somebody discretion is what pushes liability to them. Honestly, being a 316 plan administrator does not in and of itself make a fiduciary. Definition of ERISA, fiduciary ERISA, doesn't mention 316 plan administrator. That's a definition that's used for other purposes of ERISA to define responsibility. Whether you are the plan administrator or not, if you are the decision maker, fully and dedicated, that's the key. And that's what protects you, is shifting responsibility for making decisions.
Well said.
So I know that we've all been dealing with plans, or many of us, for many years. And before 316 was even marketed anywhere like it's being marketed now, we had large vendors and small vendors that would process hardship distributions, that would process loans, because most plans, at least in my experience, the hardship distributions were based upon the safe harbor reasons, not the facts and circumstances reasons that you could have used in the old days, which is a much more involved discretionary decision when you're looking at facts and circumstances than a set list of reasons and getting the documentation to support, for example, the tuition payment that somebody's requesting a hardship distribution to cover. The same thing goes with participant loans. I don't consider, to a certain degree, it's fiduciary, but it's not the same type of fiduciary duties that I see in claims administration. When you deal with a claim coming in from a participant or a group of participants under a plan, and you're administering under the plan's claims administration procedures, that's a completely different level of fiduciary duty, in my opinion. And so, to your point, though, there are lots of different types of 316 providers. Some of them are involved every day with what's going on. Other contracts that I've seen, we've already explained one where, okay, you're only adding a few other services, but more importantly, some of these other contracts I've seen is, we'll look at this stuff after the year's over. Well, wait a minute, that doesn't do us a whole lot of good. Then we got the problem that we would have had anyway. So can't we do something to integrate your services now? Still others, those agreements will say, here's what we're not going to do. And you, the plan sponsor, are still responsible for those things. And those are the heavy lifting fiduciary decisions in my mind. So I'm not saying it's good or bad. It's an individual decision for each plan sponsor to make, or the fiduciaries that are making that decision for the plan. And you have to take into account all the facts and circumstances, the services being offered, the limitations of liability, all of those issues. And that's what's important, I think, to take away from this.
Well, and I know, Troy, sometimes I've heard you and or your team use terms like robust or full-blown 316.
Oh, sure.
And I know that many of us in the industry will say, oh, well, that's 316 light. You know, there's a big difference. There's a big variance. What makes a 316 service more enhanced or full-blown? or full scope or whatever term you would like to use.
Yeah, I mean, so this is, again, I know coffee's waning on everybody, but so when 316 really started, it was 2012. And the idea behind 316 at that time was you're doing everything, as a surrogate plan sponsor for them. You're going to make the decisions as a delegated, party to do so. Over time, it's become a very kind of, distinct marketing, angle for a lot of firms that do administration in a non-fiduciary capacity. And so they've added, to Brett's point, some specific services, like maybe we'll make decisions on loans for you, or we'll do notifications that are required annually. And they'll do that in a service agreement context. So that's what kind of created these two bookends in the universe, where you had a really light model that was a service agreement model, where you did a couple functions and you traditionally were maybe a TPA prior to this. The other extreme was someone that really came from the multiple employer plan world that was used to making decisions every day on behalf of the people that joined the structure. So those are the real two extremes. There's everything in the middle today. And again, I think that's better, because really now you can match up with what you're looking to do. But I think the hard part is discerning what those differences are. And so hopefully you leave today with at least a little bit of an idea of where to look, right? But the fundamental difference is service agreement versus plan document.
And how do we
The
know
other
difference?
lens to look at it through, an important lens, is we have all this litigation going on, right? Most of it's fee related. When these class action plaintiffs' attorneys are looking at the 5,500, that's where they're digging up the data to try to make a claim that your fees are excessive. So if you're paying for 316 services out of plan assets, you better be darn sure that you can defend that decision, because what do you have to do? The services are necessary for operating the plan, and the fees for those services are reasonable. So if I'm the plaintiff's attorney and you show me the contract and it's from your TPA, and I say, show me the contract you had with your TPA before you entered into the 316 agreement. And if it has 11 items for that TPA and 13 or 14 for the 316, then as a plaintiff's attorney, I'm going to go after you. So look at it through all lenses.
Good point.
Yeah. Ted, would you add anything? Like how do we evaluate these 316 providers? Because many, to Troy's point, have started running with this as kind of a marketing idea. So how do we know the difference?
I mean, I don't know that I have a lot to add other than what was said here, which points I completely agree with. I would just say that it's important to understand who you're buying it from. That is a big issue as well. I mean, are they well capitalized? Have they been in this business a long time? Do they have a high degree of integrity for what they do? And we've got folks that are on various ends of the spectrum relative to that. So, I do think that those are important decisions too, when you look at who you're going to engage to provide as a fiduciary to provide 316 services.
Well, I mean, I think it comes down to what level of risk are they willing to take? Are they willing to work directly with the Department of Labor or IRS on your behalf? How do you evaluate their experiences? I'm not sure, apart from John's suggestion, that we have Bret review all of the the contracts. How do we know the difference between the good 316 and the bad 316? Or how do we evaluate that?
Well, you could certainly ask them as well if they have a history of paying 316 related claims. We've answered those questions, and the answer is, yeah, we've ponied up when there's been a problem and we've had a 316 and we paid there. And if there was some similarly situated contract where we were not a named 316 fiduciary, we wouldn't have paid. So that's also an avenue you can explore.
So we've been looking at fiduciary risk transfer under a number of different plan designs. I would say probably everything we've talked about applies primarily to this idea of a single employer plan. But Troy, there's this idea now of this way of doing pooled plans. So talk a little bit about what's the benefit there, and what does it actually mean to be in a pooled structure?
Yeah. So I'll tie this back to, it was shocking to me, by the way. I sat in one of the sessions earlier today where they're talking about the kickbacks or the revenue sharing off of some of these drugs. Holy cow. Yeah. There's some work to be done, right? But the thing about 401ks or any kind of retirement plans, all these roles that you see here, those are common to everyone, right? A pooled structure, whether you call the multiple employer plan, an exchange, a pooled employer plan, they all have these things in common, right? And so you can outsource the specific fiduciary roles to make your life a whole lot better. But here's the fundamental difference between a single employer plan and a pooled employer plan. Ted kind of said this a different way last night over dinner. If you were to go look at insurance and you work for an employer, the first thing you do is you pull out that packet that kind of describes all the benefits afforded to you, right? And you kind of choose the plan you want, and you're joining a group plan. If you were to go out, if you just decided to yourself, you know what, that's pretty cool and it's convenient, it's cheaper than I can do on my own, but I don't want to do that. I'm going to go shop the market by myself, right? Well, you're taking a harder road, right? A pooled employer plan or a multiple employer plan represents that very thing. It's all done for you. Like all the roles are already defined, all the service providers already named. You just decide to hop into it or not, right? And when you look at, the marketplace today, there's about 600,000, 401ks in existence. You look at like the Secure Act and all the things that promises to expand coverage. There's like 6.5 or 5 million employers that don't offer plans yet that could. That's like 65 million Americans. There's a place for something that's already kind of built, so you don't have to make those decisions. Because of that number, 90% of them have less than 20 employees, right? And those are the very people that Ted and I live with every day, that they don't have the staff, they don't have the resources, they don't have the time to get you the data that you need to run a plan, to all the things that it takes. So you need someone to be kind of running herd on that for you. So these superstructures, if you will, have all that stuff already defined and laid out. So that's why they resonate with people. It's that outsourcing that just makes their lives continue on what what matters to them. Right.
And the pool structure we're hearing a lot about these days right now is this whole idea of a PEP. So Ted, tell us what a PEP is.
So the first Secure Act passed in 2019 authorized what's called a pooled employer plan. And it's a new arrangement under ERISA. And actually, as we were talking last night at dinner, it brings into existence a new entity, which I believe is the first new entity under ERISA since ERISA, which is the pooled plan provider. So the P or the P3 or the triple P. So the pooled plan provider, and what makes it different in a PEP arrangement is the pooled plan provider is actually the plan sponsor. So that geography is a significant difference because the employer that ordinarily would be the plan sponsor now is an adopting employer onto the pooled plan itself. And the pooled plan is sponsored by the pooled plan provider. And so that really is, in my estimation, the most impactful change that was brought forth by the Secure Act. It also got rid of a couple of things for both MEPs and pooled employer plans that plagued our industry in the past, one of which is the one bad apple rule. That is, if you've got a plan within a pooled arrangement that's failing qualification, there was always this specter out there that would taint the entire thing. Now we have a mechanism, we will have perfected a mechanism once regulations are completely done to be able to roll out those plans that are failing. And then second, and probably I think the most impactful is the pooled plan provider, but another change of the Secure Act was it allowed unrelated employers to participate in a single plan. And this is something that the Department of Labor was kind of begrudgingly getting to. They had a pretty big problem with this historically in the way that they looked at pooling of qualified retirement plans and certainly looked at it with a jaundiced eye. But what the Secure Act legislation does is really take that out of their hands, and it says, well, you can actually have unrelated employers. You could have a restaurant chain in Poughkeepsie and a car dealership in Miami, and both of those could completely unrelated could participate in a single pooled plan. So that's really what was brought to bear. They first became available as of January 1st of 2021. So we're really just a year and a quarter, a little better than a year and a quarter into their existence. Said last night, I think we're kind of at the middle, maybe getting to the end of the beginning in this saga. There's still a lot to be written on what it means. But I think it's good for the industry, for those, Troy said, that don't have plans or are looking to start a plan or don't have the wherewithal to really be a retirement plan expert in administration. There's a home for them in these pooled arrangements.
I love the last point on this slide. I don't remember now which one of you added this, but I think it's really important that the service agreement, not that structure, not MEP or PEP or whatever, is really what determines the level of fiduciary risk transfer. So what are the benefits of joining a PEP? I mean,
before we jump to that, can
yeah.
I just make some clarifying comments? So pooled employer plans, they did a couple things, but they made it clear in the statute that an employer that is adopting a pooled employer plan is making a fiduciary decision in adopting that plan. I always thought it was clear in a regular old multiple employer plan that that was the rule too. However, this is in the statute. And as a result, the statute also includes disclosure requirements so that the pooled plan provider has to disclose that kind of information to the potential adopting employer, as well as a lot of other information. So it's not a complete shift of fiduciary responsibility, because you've got that fiduciary duty in the selection of the pooled plan provider and being involved in that plan and in the ongoing monitoring of what they're doing. So I just wanted to make sure nobody walked out of the room early at 4:30 and walked out thinking, fiduciary liability, we're going that way because we don't have any.
How does an employer get out of the fiduciary business?
Employer doesn't. Okay, don't have a
If
plan.
they stop having a
Yeah,
plan?
don't have a plan.
Yeah.
Go out of business.
You can have the most robust
or close up to-
316.
yeah, don't have a
You can be
business,
inside of a PEP.
Yeah, that's not the rule, the way the rules are written.
You still have
You always have
fiduciary.
some level, in my mind, I can't think of an example, you have some level of fiduciary responsibility when you're choosing one of these arrangements.
So then what are the benefits, guys, of joining a PEP?
Well, to just kind of follow up on that comment, I mean, you do, even in a standalone arrangement, if you were a plan sponsor and choosing record keeper A versus record keeping B, that's a fiduciary decision.
Absolutely. Oh, I don't think anybody
Yeah.
thought differently on that. This is just a new animal. And so as with any animals, okay, let's take the MEPs. And I've represented a lot of PEOs over the years. Maybe not in writing, but they were out there talking to their potential clients saying, oh, we take on all fiduciary responsibility.
Sure.
And that's not the case. And so that's why I think it's a.
Not even if they're the named fiduciary, 402A.
No, because you
Because
still have the decision.
still have the decision.
Say I
Right.
got $1 million plan, that's a single employer plan, and I want to go to a MEP. The decision to take that $1 million and move it from here to there is a fiduciary decision.
Is a
I don't
fiduciary
see- I don't see
decision.
how you can look at it differently.
Right.
Exactly.
Yeah.
It's just easier after.
Yeah, I mean,
Right.
you've got cost efficiencies, you've got administrative efficiencies, there are lots of other reasons to do it.
So should every plan sponsor be in a PEP? Or is that where we're ultimately moving in 5 years? All of these plans are inside of a PEP?
No, do you think a plan with 100,000 employees is going to be in a PEP? I don't think so.
So you think it's based on size?
I didn't say that. I don't think I don't think there are hard lines, but I think a company that has 100,000 employees and has billions and billions and billions of dollars in the plan probably would be putting themselves in a worse situation from a fee perspective going into a multiple employer plan or a PEP, which is just a different.
But to add to what Brett's saying, I think that the change that is happening, and we're all evidencing that right now, is that maybe the PEP or the MEP isn't the vehicle, but the offshoots of those, which would be like the delegated 316 and the 338, are becoming mainstream for all plan, for a bigger swath of plans now. So you're getting the benefits of those, even if you're not joining one of these structures.
Yeah.
Right.
We've just anecdotally, we've had adopting employers up to $50 million into a PEP. So I mean, they do have a place for larger employers as well.
50 million.
Yeah, of
I
AUM.
was talking billions.
Well, yes, and
And so when he
there's a
says,
world of
"Are all
difference.
plans going to be in a PEP?" I'm like, no.
Although
Brett
that is,
will not allow me to use all or any language like that. So that's great.
let's try to
So
think
the
of a
question
question.
is, what should a fiduciary do? Yes.
I didn't hear that.
Could you repeat the
So
question?
yeah, absolutely. I'll try to paraphrase all of that. So what are the compliance considerations? Yeah, specifically in the PEP world, what are the compliance considerations or the efficiencies or benefits from a compliance standpoint and being inside of a PEP?
Yeah, I can touch on it, and I'm sure Ted will have some comments. I think one of the things that's different about a pooled structure of any kind is that by its very nature, you're trying to design for 1,000 rather than design for one. And so the way you approach a process is very, very different. And so when I mentioned earlier, like policing data on the front end for payroll, it's always with the mindset of what happens 12 months down the road, when you're doing your 5500s. And so if you do it right, and of course we've done it wrong many, many, many times, but if you do it right, what you're doing is verifying as opposed to collecting, right? And the process is very, very different when you actually have that kind of a mindset. And I think that's born from, if not unique to, pools, when you really approach it from a standpoint of, I've got to do this for a lot of people. Therefore, the controls in place have to be very, very different.
On the investment side of the fence for our pooled arrangements, and I think it's also true with tag and trans, there has to be a common investment lineup across the entire
Yes.
pooled plan. And so you definitely do reap some of that benefit. Most instances are going to have a 338 tacked on. In the PEP space, the 338 is hired by the pooled plan provider. It doesn't have to be, but the Secure Act allows for the pooled plan provider to hire the 338.
And if the pool plan provider doesn't hire 338, who's responsible?
Right. That's a very good
That's
point.
the adopting
It always
employer
goes back
then
to
is
them.
So it's a-
responsible. And so most of the PEPs are going to, as I see it currently, are going to be set up to have
Yes.
one 338 and therefore all the same investments
Yes,
for all
right.
adopters.
That is a material difference. I mean, you wouldn't in that space when it's hired by the PPP, the adopting employer doesn't have the responsibility to supervise the 338. So that's definitely something I'd highlight. One thing that's kind of in the minutia and quite interesting actually is that under the Secure Act, at least as relative to PEPs, you have to have a trustee, a bank or a trust that houses the plan assets and is the trustee for timeliness of deposit. So
Has the responsibility for the collection of money withheld from employees' pay that should be deposited to the plan.
yes,
Now, what people are calling Secure Act 2 would change that, but don't take Secure Act 2 as passed by the Congress is what's going to happen. That's a long way away.
So what should a fiduciary do? Should they have a 316? Should they have a 338? Should they have a 321? Exactly what should they do? And that's probably the question still on the minds of some folks here. Is it
Yeah.
discharge as much fiduciary duties as possible? Is that what the provision says, Brett? To discharge as much as you.
Facts and circumstances basis, right?
Okay.
Every plan sponsor is, I don't want to say unique, but different in some respects. And so not all of them are going to need the 316. I've got some clients that they've got 20 people handling 401k matters internally.
Mm-hmm.
So they might not need a 316. Another employer that doesn't have anybody HR wise, they might need a 316. And I think, like I said before, the vast majority of plans need a trusted advisor from an investment perspective, whether it be a 321 or a 338, that's a facts and circumstances decision.
All right.
well said. I agree. Yeah.
Facts and circumstances. I didn't know if there were any other questions. I know. Thank you. I know that these guys will be joining us out here during kind of our happy hour and hour afterwards. And so feel free to ask them questions and such.
Ray and I actually have a car picking us up at 4:45.
Okay, well, two of them will not.
Sorry. But you can always call me.
Is
Or
there a
email
burning
me.
question from the audience that you want to make sure that you ask Brett? John, thanks for keeping us with your questions. I appreciate you. I didn't even have to repeat any of them. First of all, I didn't understand most of them and I didn't need to. You're loud. Any other questions? Thank you for coming and joining us today and helping us understand kind of what the fiduciary risk transfer is. So I appreciate your time.
Oh,
Thank you for inviting me.
Thank you.
Thank you all.